Good morning, everyone. My name is Kristen Mon. I am the housing coordinator for the City of Tulsa. As the housing coordinator, my role is focused on implementing the citywide housing strategy with a focus on preventing displacement and homelessness in our community. With COVID-19, we're focused on implementing strategies to prevent displacement and ensure fair housing. I would like to briefly tell you about one of the resources currently available to prevent displacement, the Early Settlement Mediation Program. It is a free program sponsored by Tulsa County and the Oklahoma Supreme Court. The Early Settlement Mediation Program provides free mediation to resolve disagreements between tenants and landlords, including difficulty paying rent and threats of eviction. A mediation is a meeting with a neutral third party to help the tenant and landlord resolve their disputes and come to an agreement that will benefit both of them. Both tenants and landlords are encouraged to apply to this free program as soon as the dispute develops. You do not have to wait to receive a summons or a notice. You can apply by calling 918-596-7786. An intake form is also available online on the Away Home for Tulsa website at awh4t.org/COVID-19-resources. For our presentation today, our goal is to provide information to tenants, landlords, and community partners on fair housing protections, as well as the fair housing complaint and investigation process. I want to thank our presenters for sharing their expertise with us and Homebase for hosting and making this presentation possible. As a brief overview of how today's presentation will go, Teresa Webster, the Fair Housing Project Advocacy Director for Legal Aid Services of Oklahoma, will provide an overview on fair housing protections, including for those who protections for those who have or are perceived as having COVID-19. Lakendra Carter, the City of Tulsa Compliance Officer, will then explain the fair housing complaint and investigation process, including potential outcomes. There will be an opportunity for questions after each presentation. Attendees' microphones are muted, so to ask a question, please use the chat feature in Zoom. Thank you everyone for attending today, and I will turn it over to Teresa.
Good morning, everyone. Good morning. As stated, I'm Teresa Webster with Legal Aid Services of Oklahoma, and I'm here to present on fair housing during COVID-19 pandemic. One second. So the goals of today's presentation are to discuss, first of all, COVID-19. Secondly, we are going to discuss fair housing on the federal, state, and on the local level. Thirdly, we will discuss the COVID-19 responses that have issued from federal and state governments. And then we'll talk about fair housing and COVID-19 and how those responses how they interplay. And then lastly, we'll have a test your knowledge, because I always try to incorporate a little bit of a quiz so that we can make sure that we're learning what's being taught. So first of all, for COVID-19, the official name is the coronavirus disease 2019. This is a respiratory disease as identified by the CDC. It's an illness that's caused by a virus that can spread from person to person. And the virus also has spread throughout the world. This is a virus that spreads by contact with an infected person, also by touching a surface that has been either contaminated or somehow exposed to the coronavirus, and then touching the mouth, the nose, and the eyes. And this information came directly from the CDC's website. Here are some statistics about the coronavirus in the United States. We see the number of cases is almost 800,000 cases with nearly 41,000 deaths. In the state of Oklahoma, there's been about 2,600 cases with 140 deaths. And in the city of Tulsa, there has been 411 cases of the coronavirus, resulting in 22 deaths. And of course, this information was the most recent information that was available as of this yesterday. Those stats may have changed as of today because they're updated every Monday during the day. For Oklahoma, these are the total cases by race, or the percentage of individuals by race. As we can see, for white alone, more than 70% of the cases of the coronavirus in Oklahoma have affected Caucasian individuals, 11% for unknown races. And then for each of the other races, less than 10% have been affected, or less than 10% of the cases for each race have, less than 10% of the cases of the coronavirus for each race have been for those races. Our statistics by gender, there have been 711 male individuals who have recovered from the coronavirus. We have 369 active cases in the state of Oklahoma. And for females, there have been 863 recovered cases and 512 that are still active. So I'm giving this breakdown because when I go over the protected classes, we'll see protected classes for the different fair housing laws, and it will give us a little bit of insight as to why we have to tailor policies as housing providers, or even as advocates. We have to make sure that policies are tailored to ensure that we're not impacting any of the protected classes in a discriminatory manner as a result of this virus. So our fair housing laws, what are they? Fair housing laws, they define what is considered as illegal housing discrimination. Now, housing providers, they have to follow fair housing laws on each level of government. So for the federal, state, and local levels of government, housing providers have to ensure that they are following the fair housing laws that apply at each level. And the fair housing rights that are given at each level of government may be enforced at that level of government, and in some cases it may be enforced together with other rights that may be triggered at the federal, state, or local level. So discussing the Federal Fair Housing Act, this has been the policy of the United States since 1968, and it is a policy that ensures that there's equal opportunity in housing. In 1974 and in 1988, the Fair Housing Act was amended to the Fair Housing Act applies to most residential real estate related transactions. It regulates the markets that are connected with residential real estate related transactions, and it includes rental sales, lending, advertising, insurance, subsidized and private housing. And then it applies to dwellings, which are buildings and vacant lands that are intended for residential use. It applies to dwellings where the resident has a reasonable expectation to return, which is opposed to transient housing, such as like a stay in a hotel or at a campsite. So we're looking at a person's reasonable expectation to return, even if that expectation is for temporary purposes. For example, for vacation homes or for timeshares where a person doesn't live there permanently, but they do have a reasonable expectation to return to those housing settings. And for the Federal Fair Housing Act purposes, these are your protected classes. They are race, color, national origin, meaning where a person comes from or is perceived to have come from, gender, religion, familial status, meaning individuals with children in the home that are under the age of 18, and then it also applies to expectant mothers, and then disability. And gender as is defined under the Fair Housing Act means male and female. The Fair Housing Act defines the term disability as in 3 different ways. First of all, it would be a physical or mental impairment, which substantially limits one or more major life activities. And those activities could include someone's ability to walk, someone's ability to breathe, to care for themselves, to be able to see, to work. Those are some examples, but that's not an exhaustive list. Then also having a record of an impairment, that would be someone who had a condition but maybe doesn't have that condition anymore. They could possibly be recovering from an impairment. And then also lastly, being regarded as one who has such an impairment. So maybe the person has never had the impairment, but if they're treated in a way where, discrimination could be inferred because they could be considered as someone who has an impairment, then they would also be treated as an individual who has experienced disability-related discrimination in violation of the Fair Housing Act. The Fair Housing Act includes, for the purposes of disability, individuals who are recovering from substance abuse, and then also maybe alcoholism, but it excludes current substance abusers, and it also excludes transvestites. Now I want to define what reasonable accommodations are, and we'll discuss those a little further down in the presentation. Reasonable accommodations are changes to rules, policies, procedures, or services, and even practices that a housing provider may have. Those changes are at the request of or for a disabled person to afford that person equal opportunity to use and to enjoy housing. Housing providers must grant reasonable accommodations for disabled persons when they are necessary to afford the disabled person an equal opportunity to use and to enjoy the housing. And the housing provider also must bear the expense of the accommodation. And usually that's because the expense to change a rule or a policy is usually very minimal. So now let's talk about what is a necessary reasonable accommodation. Reasonable accommodation request is necessary when the request is made by or for a person with a disability, and then also when the disabled person, has a disability-related need. And also the disabled person would be denied an equal opportunity to use and to enjoy housing if the housing provider denies the request. So basically what is required, HUD's interpretations of when a reasonable accommodation is necessary, basically looks at the nexus between the person's disability and the disability-related need. And so if the person can demonstrate that they are in fact disabled or they are suffering from a disability as has been previously defined, and that the request that they're making is connected to that disability, then the housing provider should grant that requested accommodation. Now, there are some reasons under the law to refuse to grant a reasonable accommodation, and I've listed them. First of all, if it's not necessary. If the person can't demonstrate that they are in fact disabled, or if they can demonstrate that they're disabled, but that the request that they are making is not connected to a disability-related need, then the request can be denied. Also, we're looking at undue financial burdens. Now, as I stated before, the housing provider is required to bear the expense of granting the accommodation. So in interpreting the Fair Housing Act's requirement to grant reasonable accommodations, HUD statements as well as Congress understood that there could be some minimal costs, but when that burden becomes unduly, the financial burden becomes undue, just an undue hardship, then the housing provider can deny the requested accommodation. Also, if it creates an undue undue administrative burden for the housing provider, then the housing provider can deny it. Or if it's going to fundamentally alter the nature of the programs and services that that housing provider provides, then the housing provider can deny it. And then lastly, it's written into the Fair Housing Act that if the person poses a direct threat to the housing community or to the health and safety of other individuals and no alternative reasonable accommodation would eliminate the harm, then the housing provider can deny the requested accommodation. For reasons to refuse 2 through 4, if the reason for refusing to grant the requested accommodation is any of those reasons, then the process doesn't stop there. The housing provider has to engage in what is called the interactive process, whereby the housing provider offers an alternative accommodation. And so basically, the housing provider and the housing applicant or the tenant or prospective tenant, whoever's making the request, they're going to bargain for something that they're going to basically try to find a middle ground so that this person can be as accommodated as the circumstances will permit. Also, with number 5, again, it says that if no alternative reasonable accommodation would eliminate the harm, then the housing provider can say no. But what the courts look at in those situations is whether or not a reasonable accommodation had been previously explored or attempted and it didn't work. So just saying, well, we thought of things that we could do and we couldn't figure out what would work for the situation is not enough. You have to actually show that you tried to accommodate the individual, and even with granting that accommodation, it would not eliminate the threat. So let's talk about what is considered as illegal housing discrimination under the Fair Housing Act. First of all, we're looking at discriminatory refusals to rent, to sell, or to negotiate for available housing, or otherwise making housing unavailable. And that term is the broadest, or that provision under the Fair Housing Act is one of the broadest because it doesn't just apply to the person who's applying for the housing opportunity, but it also applies to any other person who's affected by that discrimination. So you don't have to have a contractual relationship with the person to whom the refusal of housing has been made in order for that person to pursue a remedy under the Fair Housing Act. It's any person who has been affected by it. Also, we're looking at discriminatory advertisements, notices, and publications, and those are made in connection with the housing opportunity. Usually if the person is pursuing housing and statements are made to that individual to discourage them from participating in the housing opportunity, or statements are made that indicate a preference that they're not wanted there because of their membership in a protected class, that would be considered as discrimination. Also, discriminatory refusals to permit inspections for housing that is available for rent or for sale, and also misrepresenting that housing is not available for inspection or not available for sale when it in fact is, that would be a violation. Discriminatory terms and conditions in the and privileges in rentals or sales. Having different terms and conditions for individuals based on their membership in a protected class would be considered as discrimination. Refusing to grant reasonable accommodations when they're necessary, or necessary reasonable modifications. And then also retaliating against an individual for exercising a right that is protected under the Fair Housing Act. So retaliation can look like interfering with that individual, intimidating that individual, harassing them, threatening them, and engaging in acts of coercion against that person, also against individuals who help those who enforce their rights to the Fair Housing Act. That would also, their rights that are protected under the Fair Housing Act, those would be considered as discrimination. So now we will look at the state's Fair Housing Law, which is the Oklahoma Anti-Discrimination in Housing Act. And it pretty much provides the same protections from housing discrimination to Oklahoma residents or people who are residing in Oklahoma as does the Fair Housing Act. The Oklahoma Discrimination in Housing Act also has the same protected classes, but it extends protection to an additional protected class in addition to the Fair Housing Act, because the Oklahoma Discrimination in Housing Act adds protection for individuals on the basis of their age when they are over the age of 18 years old. Also, the Oklahoma Discrimination in Housing Act prohibits discrimination on the basis of a verifiable and reliable source of income if the discrimination is connected to a protected class. For example, if there is a landlord who charges a higher security deposit to disabled individuals whose sole income derives from disability benefits, because they are disabled and receive that type of income. That would be an example of how the Oklahoma Anti-Discrimination in Housing Act could be violated on the basis of income. For the city of Tulsa, it provides some of the same protections from housing discrimination as the Fair Housing Act and the Oklahoma Discrimination in Housing Act. It also provides additional protection to individuals on the basis of ancestry, gender identity, sexual orientation, and marital status. And the City of Tulsa's Fair Housing Ordinance, it defines discrimination as segregation or differences in treatment. But then it also has a list of other ways that specifically outline how an individual can discriminate against a person in violation of the city ordinance. It is not as exhaustive as the Fair Housing Act or as the Oklahoma Discrimination in Housing Act, but yet it still provides some protection. Now I want to talk about the difference between discretion and illegal housing discrimination. So housing providers, they are so deemed because they are in the business of providing housing, and they have to have a way to determine when a person qualifies for a housing opportunity. And so the criteria that housing providers adopt to vet applicants for housing opportunities, that's an exercise of their business discretion or business judgment. But illegal housing discrimination occurs when a housing provider excludes applicants from housing opportunities because of a protected class characteristic with or without regard to the housing provider's adopted criteria. And this can also occur when the housing provider's established criteria has the effect of discrimination, even if it's not intended. So here are some examples. If a housing provider has a policy that requires the denial of rental applications from applicants with violent criminal histories, well, that could be representative of this discretion. The housing provider could have a really good reason for not wanting people who have violent criminal histories, depending on how recent they are. On the opposite side, though, if the landlord has a policy where applicants have to have employment income that is at least 3 times the monthly rental amount, that could run afoul of the fair housing protections because people derive income from sources other than employment. And so that would exclude a whole class of individuals who may receive income from disability-related benefits, as well as retirement income for individuals who are over the age of 65. So that could be discriminatory in violation of the fair housing laws that I've just mentioned. Also, if there's a participating landlord who participates in a federal housing program that denies housing opportunities to families who have been displaced for COVID-19 related reasons, without regard to whether or not those individuals have tested positive or negative for the virus, that could be an example of illegal discrimination. So our responses to COVID-19, we have the CARES Act, which provides protection for renters and also for homeowners. We have the protections outlined here. So the CARES Act applies to properties where there is some type of federal dollar that is flowing to that property, whether it's in the form of a voucher or in the form of federally backed mortgages or some type of insurance. If there's federal money flowing to it, then usually the CARES Act is going to apply, and it restricts lessors of covered properties from filing evictions for non-payment of rent beginning March 27th and for 120 days thereafter. It restricts lessors of covered properties from charging fees and penalties for non-payment of rent beginning March 27, 2020. It restricts lessors from evicting tenants from covered properties without a 30 days notice after the moratorium expires. And then tenants living in properties that are subject to foreclosure cannot be evicted earlier than 60 days from March 18th of 2020 if the underlying mortgage for the property is federally backed. This does not apply to properties that do not have federal funding somehow connected with them. For homeowners, also it applies to federally backed loans, and then I've listed the types of loans that would be covered. If the homeowner encounters difficulty making mortgage payments due to COVID-19, the homeowner can request forbearance, and under the CARES Act, they can request forbearance for up to 12 months. It will be 6 months at a time. And then the lenders or the servicer must provide the forbearance, which suspends the of the individual to repay. During the forbearance period, there are no fees, penalties, or interest may accrue on the obligation. And then at the end of the forbearance period, let's just say that the person uses up their entire 12 months, and the borrower may have other loss mitigation options that are available to them to assist with handling arrearages, such as loan modifications. And if they can't get back on track, there are other things that they can do. The CARES Act also prohibits lenders or servicers of federally backed loans from initiating or moving forward with the foreclosure action for 60 days. And then the foreclosure moratorium applies to pre-COVID-19 federally backed loan foreclosure actions as well. And this is different than the protection that's afforded to renters, because pre-COVID cases aren't covered under the renters provisions, but from homeowners, there are protections. HUD's response basically authorizes a multitude of assistance, financial assistance to individuals to prevent homelessness. Also, their group home construction to help individuals to recover. In that setting, they are going to issue vouchers for homeless individuals and homeless families. They will provide rental, mortgage, and utility assistance for up to 24 months, and then relocation assistance for individuals with compromised immune systems, including those living with HIV/AIDS and their family members. And for more information, I will provide these slides to Ms. Mon, so that, if anyone wants to follow up with the information, you can look at the HUD's website to get more information about the relief that they're providing. In Oklahoma, our governor has issued, his executive order that provides protection for healthcare workers and their children who have not tested positive for COVID-19. So they can't be discriminated against just because they work in the healthcare arena. So our Oklahoma Supreme Court has issued directives that suspend non-emergency court hearings until May 15th, could possibly be later, unless the parties consent to other arrangements, which means that typically, evictions are non-emergency court hearings, and so they really shouldn't be happening. Our Oklahoma Housing Finance Agency is also, they've issued guidance that extends vouchers and places a moratorium on the termination of rental assistance during this time. So fair housing and COVID-19. So COVID-19 may be considered as a disability under the Fair Housing Act, even though we really don't know a lot about this disease. We don't know if it's temporary or if it has long-term effects. And so because of the way that Congress has previously defined a disability under the Fair Housing Act, and because it has extended that definition to include communicable diseases, it is possible that the Fair Housing Act may consider and may treat COVID-19 as a disability. So for rental opportunities with COVID-19, landlords are not allowed to ask a renter or an applicant to disclose the nature of a disability, so they can't come out and had it, or if they tested for it. Landlords can't evict a tenant or his family solely because the tenant has tested positive for COVID-19. Landlords should grant reasonable accommodations for individuals who have been diagnosed or for their family members, and landlords cannot exclude a person who has recovered from COVID-19 just because of the record of the impairment. As far as national origin is concerned, we've heard names in the media about what the COVID-19 is considered, where the origin of it is considered to have come from. Those statements have not been confirmed, so they're still under investigation. And so the Fair Housing Act still prohibits discrimination based on national origin. So individuals of Asian descent should not be treated differently when they are pursuing housing opportunities. And then with HUD housing funds, HUD's COVID-19 plan makes funding available in the form of vouchers as rental assistance for individuals experiencing COVID-19 related difficulties in their housing. And so in some cases, renters may receive the voucher to avoid exposure to COVID-19. In Oklahoma, landlords who accept vouchers cannot refuse to accept the voucher solely because the person is associated with another person who has been diagnosed with COVID-19, or again, for healthcare workers. So need to be mindful of that. With lending institutions, although courts have not yet decided as to whether or not lending institutions are required to make reasonable accommodations, lending institutions are required not to discriminate in the making of loans and providing other services. And so, and they are also required to use the same or uniform terms and conditions for all borrowers or people who are attempting to borrow. So in providing services that are related to COVID-19, such as forbearances and loss mitigation options, they have to provide those equally without regard to a person's protected class membership. So let's do a quick test your knowledge. I have 3 quick questions. First of all, we have Oma, who is a 65-year-old woman with an autoimmune disease. She rents an apartment at the ABC complex, which is a 50-unit apartment building. Oma's landlord has a policy that requires a monthly routine inspection of each unit. After the COVID-19 pandemic began, Oma requested to be exempted from the routine inspections because her autoimmune disease and age puts her at higher risk for contracting the virus. The landlord refused to grant her request because she felt that Oma did not provide a good enough reason to not have the inspections. So the question is, has the landlord discriminated against Oma in violation of the fair housing laws? And I can't see how many people are saying yes and how many people are saying no, but I'm going to give the answer, and I'm going to say that there's a definite possibility that the landlord has, because here this is the request for a reasonable accommodation. There is a nexus to the request, and she qualifies as a disabled individual, and so the landlord should grant the request because it's not going to create any type of burden or fundamental alteration, and she's not a direct threat to anyone, so that really should be granted. Scenario number 2, we have Ron, who is a healthcare worker with 2 minor children, ages 13 and 15. He has not tested positive for the coronavirus. His landlord knows that he is a healthcare worker. After the pandemic, the schools closed. Ron's children had to attend school at home, and they, like many children, became bored at home while Ron works and engaged in disruptive behavior. The children's conduct resulted in the landlord issuing a notice of lease termination to Ron and his family. And so the question is, has the landlord discriminated against Ron and his family because he is evicting them? And the answer is probably no. And the reason is because even though he is a healthcare worker and he has children, they are not being evicted because of his relationship to his job. Or because he works with individuals who could possibly have the virus, but they are being evicted because of the kids' behavior, and so there's probably not going to be a violation there. Scenario number 3, Bruce Lee and his family are Asian Americans who are looking for an apartment. After the COVID-19 pandemic began, Bruce applied to the ABC complex for an apartment. Bruce has a great job, great rental history, and great credit. Bruce called ahead and asked if any apartments were available. The landlord told him that 10 units were available. Bruce went to apply 30 minutes later. The landlord took one look at him and asked him, "So what do you think about that Wuhan virus?" The landlord told him that she had nothing available and did not have a waiting list, and the landlord recommended that Bruce try Shanghai Vivas. Smiling, she said that he and his family might like it better there. So the question is, did the landlord discriminate against Bruce and his family? And the answer is probably yes. So we have here statements being made, and we also have a lot of Fair Housing Act violations, and this could be based upon national origin. So the answer is probably yes. So to enforce rights protected under the Fair Housing laws, an individual can either file an administrative complaint, and I have here the statute of limitations for the state of Oklahoma, and also for HUD, if a person wants to file an administrative complaint. They have 1 year from the date of the last discriminatory act to do that. If they're filing in the city of Tulsa, then they have 180 days after the offense has been committed. The person also has the right to file a lawsuit, and that must be done within 2 years of the last date of the act of discrimination. And the person doesn't have to exhaust any administrative processes to be able to bring a lawsuit in court. They can do either or. Sometimes people do both, but then once they file the lawsuit, then the administrative process should stop. So here are some additional resources where you can get additional information about fair housing rights during the COVID pandemic. And then if you have any questions, you can always contact legal aid, and there's our website. So thank you so much for your attention. I've gone a few minutes over, but thank you for your time.
Thank you. So the question that we have been receiving is about slides, and the slides were not shown during the presentation, but we will be sending them. So the slides that were referenced, you will get copies of. I'm sorry, I think that was a technical issue that we had, but does anyone have questions for Teresa? Okay, we haven't received any specific questions, so I will turn it over to Lakendra. She is the compliance officer for the city of Tulsa and will be talking to us about the complaint and investigation process.
Good morning, everyone. Now I'm trying to make sure I don't have any technical difficulties with my slides, so give me just a moment as I bring up my presentation, please. Thank you very much for your patience, everyone. A lot of what I will be presenting on today, I'm Lakendra Carter. I'm the compliance officer with the city of Tulsa, and I work in the Mayor's Office of Resilience and Equity, formerly the Human Rights Department. And what I will be discussing with you, Teresa did discuss quite a bit of it. A lot of the information is consistent. So I may mention some things that you may have heard in her presentation, just simply because we want to drive it home and drive the consistency home, and it is also the same. But I'd like to go ahead and start with my first slide, which is, what is housing discrimination? It's basically just an unlawful or a failure or refusal to sell, rent, or lease real estate property, or a fail or refusal to lend, guarantee loans, accept mortgages, or otherwise make funds available for housing. With housing discrimination, sometimes there may be some uncertainties as to whether or not it is truly discrimination. If there's ever any uneasiness or any time you may have felt slighted when selecting housing or applying for a housing loan or a mortgage loan, always contact someone, make a phone call, call legal aid. You can call our offices for that as well. The second slide I'd like to go to is a person filing a claim under law. If they are in a protected class and they feel discriminated against based on that class, then they are definitely facing housing discrimination and should contact someone regarding their next step actions. A person can only file a claim under law if they are under a protected class and the discrimination they faced was due to their class status. So if your credit score, for example, doesn't meet the standard that that housing lender needs to get you the loan, that's not falling under a protected class. But if your credit score and you check all the boxes, everything else is great and meets the standard, however, you're of a race that the lender may not want to lend to you personally, then that is a discrimination. So with that, you would want to contact someone regarding your rights in a situation such as that. On my next slide, I would like to talk about, and again, I repeat, Tressa did mention a lot of this, so this will sound repetitive quite a bit, but again, we like for you to have the knowledge and know your rights. So there are specific classes of people protected from discrimination. There are 7 protected classes. Again, there's race, color, there's religion, national origin, sex, familial status, and disability. In addition to those protected classes, those 7 protected classes, the City of Tulsa Human Rights Ordinance, on the next slide, also expands its protection classes, and it includes gender identity, sexual orientation, ancestry, and marital status. A lot of these are things that some of us may not think of as discriminatory classes or protected classes, but there are issues surrounding these particular classes on a federal level, and the City of Tulsa's Human Rights Ordinance expands upon that federal class. So we do protect those that may have been discriminated under one of these additional protected classes. We mentioned disability and reasonable accommodation. Oftentimes, there may be some instances where an individual may need a certain type of arrangement in their apartment, or they may need certain parking access. Those are called reasonable accommodations. These are a change, an exception, or an adjustment to a rule, policy, practice, or service. And it's simply just making things necessary for a person with a disability to have an equal opportunity. Um, that is definitely a discriminatory act if someone is unable to physically get to their door, or they're physically unable to park and safely get from their vehicle to their living quarters. You want to make sure there is reasonable accommodation for them to safely transport themselves from their parking to their living quarters, inside their quarters. You want to make sure they have enough space within their living quarters to use their any type of assisted tools for them to function normally. So any person with a disability, they do have the exact same equal rights, and we want to make sure those reasonable accommodations are met to ensure that those rights are being met as well. The next slide is, why are reasonable accommodations necessary? Those accommodations are necessary because they eliminate barriers preventing people with disabilities from fully participating in the day-to-day aspects of life. We also want to make sure that be based on those living situations and those parking situations, because they do go hand in hand. We want to make sure that they're accommodating for everyone. We want to make sure that they're accessible for everyone. So that's why reasonable accommodations are necessary. We want everyone to have the exact same rights, and we want to eliminate any barriers preventing those rights to individuals. My next slide, I bring up the City of Tulsa in particular. We have a complaint process, and with that process, oftentimes with human rights, it was more exposed. With our transition of our office, a lot of people may not be aware that we still protect and we still receive discrimination complaints, and it's now done through our Mayor's Office of Resilience and Equity team. We still do it there. That process is open to any Tulsa resident who wishes to file a housing discrimination complaint. And they may do so, again, as Teresa mentioned, they may do so within 180 days of the alleged discriminatory act. The complaints are filed with the city clerk and the compliance officer, and the compliance officer is located within the mayor's office. Once the complaint is filed, the person against whom the complaint is directed is notified of the complaint so that both parties are aware, and he or she may file an answer within 10 days of such notification. In addition, once the complaint has been filed, the compliance officer or myself, I'm the compliance officer, I'll conduct an investigation to determine whether or not there is probable cause to believe that discrimination has occurred. With COVID-19, of course, I typically, prior to COVID-19, would go out to the actual location. I would meet with the actual complainant. If they are still at the location or can take me to the location or provide me the location site address, I would go to that site address. I would look at the area in which the incident occurred or the residence at which the incident has occurred. I'm very hands-on with the investigation. Now, due to COVID-19, things will be conducted a little bit differently. We'll do more interactive via computer, via telephone. We may even do more FaceTime calls. I may ask them to show me the actual space over the phone, or I'll just go to the space and not meet with anyone. But we've made the arrangements so that there's less face-to-face contact. Normally with our investigations, we're very hands-on. We're very much in contact with the complainant and the respondent. But due to COVID-19, we will be keeping the distances there. If we are able to stay the 6 feet apart, I will still go out and meet with them, but we'll definitely have to keep that barrier, that distance between each other as a preventative measure for both myself and the complainant and or respondent. The investigation still must be made within 60 days after the filing of the complaint. So that gives me 60 days to make contact, do the investigation, go to the site, take photos if necessary, and to get both parties' side of the story. If the compliance officer, myself, finds that there is no cause to believe that discrimination has occurred, I will dismiss the complaint. If he or she, or if I find that probable cause to believe that discrimination has occurred, I will notify both the complainant and the respondent and attempt to broker a conciliation agreement between the two parties. No one really wants to spend excessive amounts of time and money when we can try and mediate the situation. A lot of times, oftentimes, we found that there was just a communication breakdown or a misunderstanding in communication. So if there's any way I can mediate the concern between the two parties and broker a conciliation agreement between the two, that is the easiest and the simplest way for us to try and remedy the problem. In the event it cannot be remedied in that way, we can move to a next level. And by moving to a next level, we can go to the next slide, please. If a conciliation agreement is not forthcoming, the complaint results investigation can be turned over to either our legal team, a manager in our legal division, or it can be referred to the appropriate state or federal agency for further legal action. Again, that's if we cannot come with a conciliation agreement. In the event that it goes to that level, then we would then refer it out at that point. There are several ways you can file a complaint, a discrimination complaint with the City of Tulsa. Due to COVID-19, we don't necessarily, since we're not working in the office, we don't recommend that you bring in your complaint forms. You can retrieve those forms online at the City of Tulsa website. I've provided that link for you there below. You can complete, unfortunately, the system doesn't allow you to complete it and send the form electronically, but you can fill out the form, and if you'd like to scan it and email it, the email address is present for you there. Or if you'd like to scan it and print it off, you can print it off and mail it in to our address downtown. If you have any questions or you do not have internet access and you're unable to even retrieve the form online, give us a call or email, or give us a call at the phone number listed at 918-596-7411. We can mail you the form regular mail. You can take your time, fill it out, and then you can mail it back to us regular mail. So that's not a problem at all. We want to make sure that we meet everyone's needs and we're accessible to everyone when a discrimination has been had and we need to investigate that process. So again, my name is LaKendra Carter. I'm with the City of Tulsa in the Mayor's Office of Resilience and Equity. And again, we've provided all the contact information for you there. So if you need or know of anyone that needs to send in or have us investigate a housing discrimination, please have them contact us. Thank you all for your patience and your time.
Thank you, LaKendra. And I will remind everyone again that this presentation has been recorded. The presentation recording will be made available. We will also be sharing the slides from both presentations. At the moment, we haven't received any questions. Does anyone have questions for LaKendra? Anything particularly about the complaint or investigation process? We have one question. Have you seen any of these examples of noncompliance in Tulsa? And if the landlords don't comply, what can be done?
I have seen some of these in Tulsa. However, thankfully, the landlords have been willing to comply. And in my follow-ups, they've actually made the necessary requirements and adjustments that the complainant had. So I personally, as the compliance officer in the time I've been in my role, haven't experienced a complaint that was valid and the landlord wasn't compliant in making the necessary accommodations. I do know of some prior to me starting in the role because I was in human rights in another capacity. So I was aware of some items, some complaints that had to go all the way through legal court to get remedied. But personally, as the compliance officer in my role, I haven't experienced anyone that wasn't able to comply and get everything up to the standard as needed for the resident.
Okay. And you mentioned referring it to a legal process. Who does that go to?
Normally, I like to utilize legal aid. So I normally send most of the applicants that I'm unable to assist, I send them to legal aid. Oftentimes, most of them are in a situation where finances are restrained. So I would normally refer them to legal aid initially. And then from there, I know legal aid will either take care of them or get someone that can assist them further.
Okay. And we've been asked, have you received any complaints of discrimination specifically during COVID-19?
Not at this time, no. Thankfully, I haven't. Um, I think everyone is just kind of laying low and following, just not necessarily challenging anything right now. We are monitoring that very closely. All of our complaints, we're monitoring them very closely. We do have someone that is in the office that is still taking some of our phone calls that come in. So we are tracking that so that we can make sure we have that data to provide to the mayor. But at this time, no, we haven't gotten any, thankfully.
That is good news.
Yeah, it's great.
Any additional questions for Lakendra? Okay. Well, again, thank you everyone for participating and being part of our presentation. As I said before, the recording will be made available along with the slides. Thank you everyone and stay safe.